Okay. Welcome, everyone. Thank you for joining us today. My name is Jamie Schenker-Passero. I'm the Associate Director of Temple Small Business Development Center. We help small businesses start and grow. These days, we are assisting businesses with responding to the pandemic, and we're doing that with virtual consulting and virtual training. So if you are a business and you have a need to speak to a consultant, you can connect and have individual sessions. We can help with pivoting, we can help with maybe projections. If you have questions about the disaster relief programs, we can work with you on navigating that. We are also hosting office hours. If you have quick questions, that's 3 to 5 p.m. Monday, Wednesday, and Friday. So that's available to you as well. On the training side, we are offering virtual events to try and assist and help you become more educated with all the tough decisions that you're making now. We're also gathering resources that could be useful for you right now. In the chat, I will post a link to that resource page, which also has our upcoming webinars. It also has links to recordings of previous webinars and how to speak with our consultants and how to access our Zoom hours. We are funded by the Small Business Administration, and that allows the majority of our programs and services, including our consulting, to be of no cost to you. Today, we have a really specific webinar, and this is very timely. And this is going to speak to your contracts and lease agreements and working out how to make them work for you right now, and some potential legal ways to just get some relief right now. So we are joined by two lawyers. We have Norm Powell, who is a partner at Young Conaway in Wilmington, Delaware. His primary interests include secure transactions, alternative entities, and third-party legal opinions. He's an elected member of the American Law Institute, immediate past president of the American College of Commercial Finance Lawyers, and the current content officer of the American Bar Association's Business Law section. And we have Jonathan Lipson, who is the Harold E. Cohen Chair and a professor of law at Temple University Beasley School of Law, which is my alma mater. He teaches a variety of business law courses, and his research focuses on corporate governance, restructuring, and contracting. He is an elected member of the American Law Institute, a fellow of the American College of Commercial Finance Lawyers, and is active with the business law section of the ABA, where he is an immediate past content officer and is now a member of its council and the Corporate Laws Committee. So they actually reached out to us with something that they put together to benefit the greater good. So you don't always hear that from lawyers, but in this case, these two came together and created something that could be accessible for small business owners to use, which is really, really amazing. And they're going to break that down for you. And I'm going to link in the chat box an article that they put together that has links to where you can find a template and some notes about what they created. So you can take it away. Thank you so much for joining us.
Great, Jamie, thank you. I'm Jonathan Lipson, as Jamie said, and what we're going to talk about in particular today is something called a model standstill and tolling agreement. And as Jamie suggested, in essence, it's a kind of temporary agreement that you can enter into with contract counterparts with whom you might be having trouble due to the pandemic. That's the goal for today, talking about how this works.
So first, let's get this out of the way. We recognize that anyone listening to this program may have very specific needs and may have specific circumstances that warrant consideration. We are not familiar with those needs or those circumstances. We're giving general advice today. We're suggesting an approach that we think, and we've seen from many instances, may in fact be preferable to some other approaches as people work their way through the economic disruptions of COVID-19. We're not your lawyer. We're not giving you legal advice. We're giving you general ideas that you can pursue on your own with counsel of your choosing, what have you. The back half of our slide deck will actually be a walk through a model standstill and tolling agreement. That'll all make a little more sense, I hope, when we get to it. But we originally published that on April 13th, 2020 just a little over a month ago. And at that time, we thought that, gee, maybe in another 30 or 60 days, we'll have a much better idea how the world's going to come out of this thing. I, for one, am still having the same thoughts. I don't have much greater certainty, although I know we've started to sort of open things up, and I'm sure many of you with businesses are looking at that both with excitement and with trepidation. But we recognize as well that even as the recovery begins, it's not going to happen overnight. It's going to take some time for revenues to ramp up, for performances to get back to where they were. So we think this remains very timely. So with that out of the way, we'd like to talk a little bit about the problem as we saw it and this solution as we envision it. Jonathan.
Great, thanks. So the problem in a nutshell is that if you step back and think about what's happened over the last couple of months, one thing that is probably true for many, many people in business is that the contracts to which they are party are in breach. People in business make promises to one another in contracts all the time, and for many reasons, it is highly likely that many of those contracts are in default in some way. For example, a tenant might not have been able to pay rent when the rent was due. A borrower may not have been able to repay a loan, make a loan payment when it was due. A buyer or seller of goods might not have been able to purchase or deliver goods as promised in a contract, and so on. In those cases, right, a natural response is to do one of two things: either to go to court, litigate, because you're upset that the promise has been broken, or to do nothing, to put your head in the sand, hope that things get better, and just ignore the problem. We think, for the reasons that we'll explain as we go through this, neither of those is a particularly helpful solution, but instead the solution that's probably going to be most useful to most people most of the time is to enter into an interim agreement that we call a model standstill and tolling agreement, that in effect is a timeout and freeze in the contractual relationship, which we hope will give the parties the breathing space to figure out what's going to come next and adjust accordingly.
So who are we? Well, Jamie was kind enough to introduce us, and you know that Jonathan's a full-time professor at Temple, that I'm in law practice in Wilmington, Delaware. Jonathan mentioned a moment ago that it's our view that for many people, litigating is probably not the best solution at this time. As I say, I'm a lawyer in practice, and I share that view. Litigation takes a lot of time from start to finish, takes a lot of your attention, a lot of time during its pendency. Time is probably better spent on other things. And as we're going to try to make clear in the first portion of our slides, there are a lot of uncertainties. There are some terms that many of you may be hearing: force majeure, act of God, impossibility of performance, frustration, unjust enrichment. And some of these things have a visceral appeal that makes it sound like, yeah, that's me. That doctrine should come to my aid, and this should be a slam dunk. And we suspect, and we can share with you, and we'll share with you some cases that suggest, for better or worse, it's just not that simple or cut and dried. And so we understand there's a natural inclination, if you're owed money and it's not forthcoming, to start exercising your rights. But we don't know how the world is going to look in a month. And it's very difficult to meaningfully change your position in a contract when no one knows what the world's going to look like during the time that contract pays out. That's why we're suggesting a timeout, an opportunity for people to preserve what may well have been a very positive and mutually beneficial business relationship until we get a better idea what life is going to look like on the other side of these unprecedented times. Jonathan.
Thanks, Norm. I think that's great, and that's correct. Norm, just a little bit more about who we are and why we're doing this. Norm and I are not only both teachers at Temple, but we're both active with the business law section of the American Bar Association. And the model agreement that we've created, that we'll share with you, was published by the American Bar Association in their electronic magazine called Business Law Today. And as you'll see, it's freely available to anyone who wants to use it. We have published a short article that explains what it's about. And you know, through our experience in the American Bar Association, not only do we know each other, but I think we know that by and large, efforts to preserve functional relationships are well worth taking. And so that's what is motivating us here. We think that greater economic good, greater social good is likely to come from enabling people to keep their relationships intact through this otherwise uncertain and scary time. So the roadmap is pretty straightforward. We'll first talk about the problem, the fact that COVID-19 has produced really massive potential breaches of contracts that result either in a denial of what's going on or litigating, and our solution, this contractual or transactional solution known as a standstill and tolling agreement.
So what sorts of problems or breaches do we intend to cover? Well, an obvious one that comes to mind is payment, right? Somebody has borrowed money and is unable to pay it back. Someone is obligated to pay rent and is unable to pay the rent. There are any number of monetary obligations. And as we get into the form later in our presentation today, you'll see that we've adopted the nomenclature of debtor and creditor. Now, we had to pick some sort of words to describe the parties, and we chose those because we thought that made sense in a lot of contexts. You may find that there are other contexts. So maybe somebody is supplying someone with a product, a good, a service, what have you, right? So it may be provision of services or widgets or what have you, and someone just can't get the inventory, can't get the supplies, can't get the raw materials, whatever it might be, can't in fact open and operate their business to create or transport the thing they're obliged to produce and deliver. There's any number of different sorts of breaches we're speaking of. The second bullet point on this slide mentions covenant defaults. For those of you who spend more time looking at your contracts as opposed to running the businesses that you've created, covenant defaults, of course, are those things that are typically like a second line trip, right? You'll have financial and performance covenants. You'll have performance covenants that tell you you've got to pay X amount, you've got to do this, you've got to do that. And then you'll have various covenants that typically, well, once you start to stumble, some of these things will fall as well. Financial ratios, notions that you won't be in default under any material agreement with anyone else. Well, when the house of cards starts, when the wind starts to blow as it is now, it's very, very difficult to have only one defaulted relationship. So we try to recognize that all of these things could have some application here. We talked a little bit about material adverse events. Jonathan, you may want to add something here, but I think we're going to do a lot of discussion on that in the next page or two as we set the stage for why we think that some of those litigation-based approaches are probably not optimal for many people in our audience.
Sure, I think that's right. When in sort of the normal world, people encounter a default of the sort that Norm just described, I think a very natural response is to be upset about it, and in some cases to run to court, to hire a lawyer and sue, or to worry that the other party to your agreement will hire a lawyer and sue you. And today we live in a world where, as we suggested, almost every contract is in some kind of default, either a performance default or a covenant default or both. In the ordinary course of things, when there are defaults that are caused by unforeseeable significant problems, for example, a pandemic, over time, courts have developed what are called doctrines, responses that in some cases will excuse the default, will excuse the breach, and enable the party that is in default or in breach, in effect, to not have to pay damages, not have to provide a remedy to the party who claims to have been in breach. And the first of these is called force majeure. We'll talk about several of them because these are the ones that you're most likely to hear about, the ones that are most likely to be thrown around in your discussions with your contract counterparts. Force majeure is, it's a legal French term that means, essentially some unforeseen force outside of the contemplation of the parties. A force majeure clause is a term in a contract, written contract, that simply says essentially, here's a list of really bad things that might happen. And if any of these really bad things happens, then one party or the other party or both parties will be excused from performing. Meaning that if the really bad thing happens, then it's not considered a breach. Courts, are occasionally asked to assess whether these sorts of provisions are in fact triggered by particular types of events or they're enforceable. And courts have developed tests for deciding whether to enforce them. And the test is, it's a two-part test, says, is the claimed event, was it truly beyond the party's control and not the result of that party's own fault or negligence? And did the party try to perform the contract? Now, as you'll see, I would guess some of your contracts contain force majeure clauses, some do not. They can be quite elaborate or quite simple, but you should, immediately see that the test that courts use is pretty fuzzy. It's not entirely clear because we don't know what it means to say, was something truly beyond a party's control? Well, the pandemic clearly is beyond your control and beyond, not your fault. But what does it mean to try to perform? How much more could a party have done or not? Those are things that litigators love to fight about, but maybe spending money on litigators fighting about that isn't the best use of your resources.
And, when we have a contractual force majeure, it becomes important to consider exactly which words were chosen to constitute that phrase. A force majeure in a contract, it's not like a can of Coca-Cola, right? Which is exactly the same no matter where you buy it. You open it up, you know exactly what it's going to taste like and the refreshment you're going to get from it. A force majeure clause really depends which words were put into it. Some of them are bidirectional, so either party can be excused. Some of them are one directional. And some of them are very detailed. And details can be good or bad. We have a couple of cases, and I just want to give you a couple of highlights just for sort of the color here. The Pacific Collective versus ExxonMobil case. So, ExxonMobil, right? We're talking some big players who maybe have the deep pockets and the appetite for protracted and expensive litigation. But in this contract that's at issue here, in this case, the force majeure clause specifically defined 18 different catastrophes, 18. As constituting force majeure. It did not include among those 18 the words pandemic, epidemic, or contagion. And so we come upon one of these awkward sort of realities in the law. The longer your list, the more likely a judge or jury may determine that the things not in your list were not intended to be covered by your language. Right? The more specific we are in a long list, the harder it is to argue, oh, well, those were just illustrative and I meant anything like that. Really, you needed 18 and you... So that's one example. The only other one I want to bring to your attention in particular is the E2W case. And this involved an amusement park. And so the amusement park was a franchise and they had to shut down. There was actually, a state level order mandating that they shut down. Well, if you shut down, you're not exactly bringing in a lot of revenue. And so before long, the operator said, I guess I can't pay my fees. I can't pay my franchise fees. And so I'm going to skip. And of course, the rejoinder comes back, well, government said you can't operate, didn't say you can't pay. So you don't have an excuse. So again, the words mean a lot. And they really, you can spend a lot of time and a lot of money and have a lot of time lapsed if you choose to litigate things like this. Our guess is for many of you, that's probably the least healthy or appropriate thing to do for your business, whether right now or in the longer term. Because again, we suspect that many contracts that are currently in difficulty or default are basically solid contracts among people who have very productive business relationships and may want to think about preserving those relationships for future. And of course, litigation is hardly a road to that sort of preservation. Jonathan.
Yeah, good point, Norm. And one of the things to notice about just the 4 cases that we've listed here is that they were all filed. These were litigations commenced
Yeah.
all within the last month and a half. So there's been no resolution in any of them because, of course, litigation takes time, and there will be different views of what the language in each of these contracts means, which again is good for the litigators, not necessarily so great for the paying clients. A second thing that you'll hear people talking about in addition to force majeure is the idea of what's known as impracticability. This is the idea that even if you don't have a force majeure clause in your contract, the common law, judge-made law, has developed over time to excuse parties to contracts, excuse parties from performing where some really, really bad thing has happened that wasn't necessarily contemplated by them. Here, courts have developed a three-part test. Number one, something must have happened which was, assumed not to have occurred when the contract was made. Number two, that occurrence must, make performance exceptionally difficult. And number three, the parties couldn't have reasonably foreseen that the problem would occur. As with force majeure, right, this test certainly makes some sense, but you should see that there's enough fuzziness in each element that, it could be a field day for litigators, even though it's not necessarily helpful to the parties to have a full-blown litigation. As Norma mentioned a moment, this overlaps with a related doctrine that you'll sometimes hear lawyers throw around, known as impossibility.
And so impossibility, just as the word suggests to all of us, means you literally can't do it, right? A classic example of a contract defense of impossibility of performance is, oh, Jonathan hires me to paint his house, and then, God forbid, his house burns down. I literally can't paint the house. There is no house anymore. That's a classic example of impossibility. Once you get into the realm of, well, it's really hard, it doesn't make sense, it's prohibitively expensive, there will be delays, you're back into impracticability. And that's that much harder in terms of sort of gradations. So we do note that these doctrines are widely available in a number of states, and we don't suggest that in a given circumstance, maybe pursuit of them might not be appropriate. But our surmise, our sort of working hypothesis when we started this project together is, for a lot of people, this is just way too much time spent, time lapsed, and money gone out the door, as well as the destruction of relationships that many of us are going to want to keep intact for when we all come out of this on the other side.
Norman, we had a question about frustration of purpose and how that relates to what you were just talking about. Is that the exact same thing as impracticability or slightly different?
Yeah, so it's a little bit different. Let me pick up with that analogy. Let's suppose Jonathan contracted for me to paint his house and the house had burned down. That's our classic impossibility of performance. Frustration of purpose, well, to continue with the example, let's suppose I had gone down to the paint store and ordered paint specifically and disclosed, and it was known by me and the vendor that I was ordering special paint to paint Jonathan's house. This would be a frustration of purpose. I couldn't possibly use that paint to paint his house because his house has burned down. So those two will sometimes sort of go together. Frustration of purpose is kind of like what's the point? You can't do it kind of thing. The fundamental purpose known to the parties, known to the paint vendor and me, everybody in my, so I didn't go to Lowe's, I didn't go to Home Depot. In this hypo, we all knew and agreed that I was buying this paint solely for the purpose of painting Professor Lipson's house. And because that purpose has been completely frustrated by the destruction of the house, that may allow me to get out of that contract.
Right, it's the difference between the house burning down and rendering the performance of the contract impossible and the specific purpose of buying the paint, which has been rendered impossible by the house burning down. Closely related.
Perfect.
Sets of doctrines, but slightly different.
Okay, so we're about to transition. We've mentioned a couple of times the amount of money spent, time lapsed. let's talk about a couple of other things that folks can often overlook unless they've had recent experience with litigation. The odds of collecting, right? Even if you put in the time spent, time lapsed, the money, you don't get a check when you walk out of court, right? Remember Rusty the bailiff on the People's Court? He doesn't work in real life. So no one gives you a check as you walk out of court. You have a legal right to collect the money. Now you have to go collect the money. Does the person you're suing have the money? That might be the very reason you've been suing them in the first place, right? Because they literally didn't have the money. And that's why they didn't pay you in the first instance and blew up their business and your good contractual relationship and so on and so forth. So for all these reasons, we think that for a lot of people, it makes sense to pause and consider calling a timeout. That may lead to making substantive changes to salvage the relationship as best it can be salvaged to move forward. That may mean salvaging the relationship so that it can restore to exactly what it was before this came upon us. But until we have a better feel for what it looks like on the other side of what we're currently going through, we think it might make sense to just call a timeout. And so our model, standstill and tolling agreement.
So this is essentially a substitute temporary contract that is intended to, as Norm suggested, freeze the legal rights and obligations of the parties for a limited period of time. So when we say standstill, we mean literally the parties will stand still and not sue each other. When we use the word tolling, you'll see what we mean is we're pretending that for legal purposes, time is not passing. That can be important because things known as statutes of limitation can eliminate a cause of action, a right to sue, in the absence of an agreement to stop time in that way. So our form, our model, which again you can get for free on the ABA's website, starts like many contracts start. It has a preamble, and that preamble, simply sets forth, the very basic predicate terms in the standstill agreement. So this agreement is made this blank day of blank. Well, if you go to our form, you'll see it can be completed electronically online in a very short period of time. So whenever you see boxes that have the words key here, that literally means you put in, the day and date that are salient to you and your contract counterpart, and then the name, of the debtor and the name of the creditor. And as we'll explain in further detail, that can be any number of types of parties. It may be the borrower, the debtor may be the borrower, the debtor may be the seller, the creditor may be the lender, the creditor may be the buyer. The key point is to understand that we're setting up at the very front end of the agreement what the agreement is speaking, when the agreement is speaking as of, and who the parties to it are.
Now here we pick up with another common element at the beginning of a great number of contracts. These recitals or whereas clauses tell a little bit of the contextual story. Why are we doing this? Well, debtor and creditor are parties to certain, I'm reading from the first such clause, that certain, and this is where we would make reference to the underlying contract, the contract that may be in breach or may soon go into breach. So as Jonathan mentioned a moment ago, we're calling our standstill agreement, of course, the standstill agreement. And just for clarity, in this whereas or recital clause, we're referencing what we're going to call the underlying agreement. Maybe this was the documentation, and maybe more than one document, maybe several interrelated documents, but this might be the supply contract or the loan agreement or what have you. And then we proceed to set the stage a little more. We say the debtor and creditor recognize that the COVID-19 pandemic has caused or may cause substantial disruption in commercial relationships, right? So that's the context in which we're doing this. That's why this standstill agreement is being entered into. Such disruptions may result in breach of various contracts and result in efforts to enforce rights and remedies and things like that. The parties agree to avoid all of that for the time being and call a timeout, standstill, until they have a better idea of what would be an appropriate reordering, if any reordering, of their relation on the other side of this. And then we sort of proceed into the substance of the agreement itself. Jonathan.
Thanks, Norm. And one other point about these things called recitals. I think many folks in business will read the contracts that they sign, but they don't necessarily understand why lawyers have, included the sorts of things that they've included. And as Norm suggested, here these recitals are setting the stage. They're helping the parties to remember why they're doing this at all. They're also helping any future readers understand why this is happening. Who might those future readers be? Well, if, God forbid, things don't start to get better and there's a dispute under this agreement, then we want people to know why this was happening in the first place. For example, a judge in the future might need to understand, why did you enter into this standstill agreement in the first place? So we're setting the stage here in order to move into the first of the operative terms, and that involves the scope. The scope is simply where we define what we're trying to have a timeout on. So we say this standstill agreement covers the rights and obligations provided for in the underlying agreement, in the loan agreement, in the lease, in the supply contract, and those reasonably anticipated to arise under the underlying agreement during the term, capital T, as defined below, of this standstill agreement. We then define those issues as the standstill issues because we want to make it clear it's certainly possible that there are other disputes between the parties, other problems between the parties, in addition to and separate from those involving the underlying agreement. The scope of this standstill is intended to address only issues that arise under the underlying agreement and not any of those other problems. So we're trying to have some clarity as to what people are agreeing to take a timeout on and what they're not agreeing to take a timeout on.
One final thought on that. If any of you have been through a sort of specifically negotiated forbearance agreement, for instance, with a commercial lender, you'll find that often the scope of what's being waived or what they agree to forbear is very specifically tailored. That takes a lot of time and specific research and negotiation. Here again, our presumption was people may wish to consider a broader application of the standstill agreement to all of their obligations arising under the underlying document, the underlying agreement, with a few exceptions that we're going to detail as we get forward, recognizing that some performance may continue to go on, right? Maybe you can't make the full supply of whatever it was to be sold, but you can make half that or 2/3 that or what have you. Let me speak to term number 2, term and termination. So this is fairly simple and straightforward, right? And this tells us the standstill agreement will take effect as of its date, whatever date we put in up at the top there, and will continue for, and here's a place where we can put in a period of time, 30 days, 60 days, 90 days. And of course, that can be terminated by mutual agreement, cut short. That can be extended further by mutual agreement or renewed, if you will. But our thinking here was, listen, if people think it's appropriate to call a timeout, they don't mean forever. They don't mean 10 years. They don't mean 5 years. They mean whatever's comfortable for them. And if at the end of that, the certainty they thought, indeed, I mentioned earlier, when we were doing this, when we started this about 6 weeks ago, we imagined we'd have more understanding by now, by mid to late May, than I think either of us believes we do have. But, pick a number that's comfortable. And then if you want to re-up, terrific, re-up. But pick a number that's comfortable. That's what goes in here in term number 2. Jonathan.
Term number 3 is the creditor's agreement to stand still and to toll any statute of limitations, any time period that might be legally relevant. So the model agreement says that during the standstill period, the creditor shall not take legal action against the debtor, right? And that's what standstill means. Nothing fancier than that. Any applicable statute of limitations or other period of time relevant to either party's exercise of rights or remedies in connection with the underlying agreement is also tolled or frozen during the standstill period. And the idea here is that we want a mutual timeout. We want the party that might be able to take legal action, whether it's to go to court, to foreclose, to agree not to do that, but to not be penalized legally for having agreed not to do that because, for example, the passage of time might cause the statute of limitations to expire. We also ask that the parties agree not to transfer their rights under this agreement. That's in part to help preserve the parties' relationships. If the lender, in some cases, lenders might be tempted to sell their rights under a loan agreement, for example, in order to simply cash out of the problem. And this is preventing that for a short period of time, again, in order to induce the parties to try to renegotiate and work together during the standstill period.
So term number 4 is basically the debtor's reciprocal agreement not to enter into non-ordinary course acts and things like that. And so what we've done here is we've simply said, in effect, that the debtor isn't going to take actions that ultimately make things worse for its creditor. Truly, everyone is observing the timeout. No one can move the ball either way. It's truly a timeout. So, for example, here, the debtor's not going to sell all his assets, right, or give them to his brother-in-law, or things like that. Not going to radically change the structure or form of the business in a way that would ultimately redound to the detriment of the creditor. It's a true timeout. Nothing happens during a true timeout except those things that we've agreed are going to happen during the timeout. And that's a segue, I think, to our next several slides. Jonathan.
Sure. And one of the things that you might note here is that, especially with respect to terms 3 and 4, which are really the heart of the agreement, they're pretty straightforward. If you were to hire a lawyer, or if you were a lawyer negotiating one of these things, as Norm suggested earlier, they might be considerably more elaborate. There are many, many, many things that could be specified in each of these terms, numbers 3 and 4. And we've deliberately chosen to keep it simple precisely because we think it's important for parties to be able to use this quickly and easily and not to worry too much about details that are unlikely to have significant benefit to the parties.
Certainly not benefit commensurate with the expense of attending to those details.
Right.
Yeah.
Term number 5 is a somewhat unusual provision in this kind of an agreement. It's asking the parties to engage in good faith negotiations during the standstill period and to try to collaborate with one another in efforts to fix the underlying problem. For example, to obtain new financing or other relief. So, for example, if one of the parties needs to obtain or is seeking to obtain financing under the CARES Act, but happens to be in technical default with his or her landlord or bank or what have you, this standstill agreement is not only saying that the landlord or bank can't take legal action, which might complicate taking the CARES Act financing, but in addition, the landlord or lender agrees to cooperate in order to help the borrower or tenant obtain this new financing. Again, because we think that that preserves the relationship, it's in everyone's best interest to try to do that sort of thing.
Interim consideration. So here's a contractual term that we see almost anywhere in a contract, this notion that each party gives something of value to the other. And that's what supports their mutual obligations or agreement and supports enforceability of that agreement. So here we speak of the specific consideration that we will have each in favor of the other. During the standstill period, debtor agrees to provide to the creditor, and here we're going to insert things that might in fact continue during the contract term. Now there may be no continued performance because we may have a full sort of shutdown for the interim. We may, on the other hand, have continued partial performance. Likewise, we have a reciprocal statement during the standstill period. The creditor agrees to provide to the debtor, and then we can key in whatever might be an ongoing performance on that side of the contract. Jonathan?
Yeah, this is like term number 5. I think this is slightly unusual in this kind of agreement because it's contemplating the situation where there doesn't necessarily have to be a complete freeze in the relationship, even though there's a freeze in legal action. And so this is creating the opportunity for the parties to say, well, here's what I can do. I can't do everything I promised, but I can do some things that I promised. And here's where you'd specify what those some things are, if any, and if there are none, then all I say is none, right? Term number 7 is where it starts to sound pretty legalistic, and that is because it talks about breach. Breach, as you all know, is the legal term for the condition in which a promise in a contract has been broken. A contract is breached when one party has failed to perform the promises that it said it would breach. It would perform the promises that it said it would perform. What we're doing here, however, if you read it carefully, is we're trying to be very specific and careful about exactly which violations of this agreement might be a breach of this agreement. And so we say that a violation of paragraph 3, that's the paragraph where the creditor says they will stand still, is going to be considered a, quote, creditor breach. Any violation of paragraph 4, that's the paragraph where the debtor says they're not going to take any extraordinary, unusual, non-ordinary course action. Any violation of paragraph 4 by the debtor will be a debtor breach of this standstill agreement. Now, why do we bother to do that? Why don't we say, well, any violation of anything in this agreement is a breach? We do this because we want it to be clear that paragraphs 4 and 5, the ones talking about good faith negotiations and interim consideration, those probably aren't enforceable by a court. And so we don't want to set up an invitation to litigate about them if there's some question as to whether the negotiations were good faith enough or whether the cooperation was sufficient. Those sorts of things are left purely to the honor and goodwill of the parties. What we're focused on for legal purposes will be the standstill, the tolling, and the sort of timeout features of this agreement.
And so from breach, we flow logically enough into remedies. If there is a breach, what happens next? And here again, you'll see why we structured this the way we did, because just as the agreements, the core agreements by each party are a little different, right? I'll stand still and not enforce. Well, I won't mess around and make it harder if ever someday you do when the timeout's over. Likewise, the possible sort of incentives or rewards to behavior, if you will, are a little different on either side. So from the one side, in the event of a debtor breach, the creditor can pursue any legal action that he has as though this agreement hadn't been entered into, right? So the debtor is given this relief of, hey, creditor's not going to come after you just now, you get a timeout. Well, debtor, if you violate this agreement, then creditor, in fairness, probably shouldn't be held to that and should be able to pick up his various tools and pursue his various remedies and so on and so forth. Let's look from the other side. What if the creditor breaches the standstill? Creditor agrees, you know, I might be technically allowed to sue you and exercise some remedies against you, but I agree I'm not going to do that for the next 30 days, whatever it is. And what if the creditor says, you know what, change my mind on that. I'm going to come after you tomorrow. I'm breaking this promise to you. What should be the consequence of that? And our thinking was, well, they should forfeit any rights that were supposed to accrue during the standstill period. So for instance, if default interest would not have accrued but for that breach of this agreement, then it doesn't accrue. If you were already into default interest rates and what have you before you stood still, well then when you stood still, there was default interest. But we take away what we might call sort of the incentive, if you will, that a creditor might say, you know, I finally woke up to the fact that if I hadn't entered into a standstill, gosh, the week later, my guy would have owed me default interest or penalties or what have you, and that's looking pretty attractive to me, so I'm going to tear up the standstill. Our thinking is, that's not the way it should work. You've agreed to this, let's honor it from both sides. Jonathan?
Yeah, thanks, Norm. One of the, I think, intuitions here is that we want this agreement to be as balanced as possible. And so the creditor needs to feel at least a little bit of pain if they breach. And so what they're giving up is, in essence, the right to collect anything that they otherwise would have been entitled to during the standstill period, as Norm suggested. That too is slightly unusual. Very frequently, forbearance agreements really talk only about the debtor's breach and not at all about things that a creditor might have to give up if they breach. But we think that a balanced agreement is probably a healthier and more functional one. Term 9 is pretty legalistic looking stuff, representations and warranties. I'm sure that you've all seen contracts that have these things in them. These are things with legal significance. A representation is a statement about either the condition of the party or the condition of the world in which the party is operating, a statement of fact. And warranties are promises of a similar sort, but on an ongoing nature, on an ongoing basis, rather. Contracts will often have very elaborate representations and warranties that can go on for pages and pages and pages. You know, consistent with our overarching goal of making this easy and fairly painless for people to use, we didn't think you wanted pages and pages and pages of representations and warranties. So we really only have one, but we think it's one that's important. We want each party to represent and warrant that they have the power and the authority to enter into the agreement, and to recognize and agree that the agreement will be legally binding when they do so. This is important, for example, if the parties are not individuals acting in their personal capacity, but instead entities, for example, corporations or limited liability companies, where certain additional steps have to be taken to make sure that the entity, the organization, has in fact got the power and the authority to do this deal, to enter into this standstill agreement. And so this is a reminder to the parties that if that's the case, if you are doing business through an LLC, you need to make sure that the LLC has the authority to enter into this agreement.
So term 10 is a very short one, and this doesn't call for any interaction from people using the form. It's really just a recognition to give people peace of mind that this document, this agreement should work, whether done old-fashioned paper and pen, or given the times in which we're living, both technologically and biologically, if people prefer to do this electronically. There are a number of laws, both federal and state, that stand together for the proposition that pretty much any contract you could enter into with a pen and paper, you can enter into electronically with documents that you exchange along with, you know, sort of marks of authentication. We tend to do this many times on our computers as we fill out forms or consents or what have you. This is really just intended as a nod to that, again, to maximize people's comfort as they complete and use these in the way that suits them best.
Term 11 involves what might seem to be a kind of detail of little consequence, but we think is actually quite important, and that is notices that need to be given to the parties under the agreement. What we recognize is that during the standstill period, the ordinary ways that the parties might have of communicating with one another under the underlying agreement might not work. For example, people might not be going to their factory or their plant or their office as they normally would, and so they wouldn't be receiving mail there. Well, the underlying agreement might say if you want to send a notice about a default or something like that, under the underlying agreement, that's where you're supposed to send it. Well, that's a problem. So one of the things we wanted to provide for in this standstill is interim addresses or notices, whatever sort, electronic or physical, that the parties can use in order to be able to reliably communicate with one another during the standstill period. So when you complete this agreement, you simply key in to these boxes where and how it is that notices under the agreement are to be provided. Probably these will be email addresses. And the notice we're talking about most likely is a desire to either terminate the standstill agreement or to continue the standstill agreement.
And that brings us to the last section, and it's worth lingering here for just a moment because this continues a thought Jonathan introduced when he was speaking to you about the representations and warranties, and mentioned that some parties may in fact be corporations or LLCs or what have you. Here we've set up for keying in for completion fairly typical format for signature blocks. So here you'll see signatures, key here, a blank by blank. And so you might say that would be, Acme Corporation, a Delaware corporation by Joe Smith, president. And if you pause to complete a signature block like this, you're given an opportunity to consider, oh yeah, this isn't Joe Smith himself as an individual. This is a corporation that's intending to bind itself to the contract. It's Acme Corporation. And there again, hearkening back to item 9, you might think, oh, I wonder if the corporate board should consider this contract, should consider and authorize it's being entered into by this person. Is Joe the right person, right? Well, what office does he hold within the entity? So that's what this is intended to do. Similarly, we may have Acme Limited Liability Company, right, which might be a little different. Limited liability companies are generally run by their members, unless of course they're not, in which case they're run by their managers. And we're off to the races with all sorts of variations, but hopefully you know your entity structures. This is just intended to slow people down a little bit, to remind them, think about that. It may not be you in your individual capacity, maybe you in a representative capacity for a juridical entity. Jonathan.
Those are good points, Norm. And also we've set it up this way to balance the desire to make it easy to do on the one hand, but also to make it clear that it is a legal commitment, that we expect the parties to intend to be binding. And so although this looks perhaps a little formalistic, we think it's essential in order to make the standstill tolling agreement effective legally.
I think it's fair to say it's the shortest and simplest document that we've ever written. And I think, in a nod to Abraham Lincoln, to make it this short actually took quite a bit of effort.
Right. If we'd had more time, we would have said less.
Yes. So.
And so the conclusion, I think, is fairly straightforward. We think that there are many important things that all of us can be doing during the crisis to ameliorate the crisis. But we think that commercial litigation is not likely to be one of them, at least in the near term. We think that, if things, get really bad, obviously people are going to need to rethink a whole lot of things. But we're cautiously optimistic that although it's taking longer than we might like, things will get better, and that as and when they do, we'll all be better off if we have made efforts to preserve our relationships wherever possible rather than to destroy those relationships. So rather than, litigating, we think that creating space and time to communicate, to adjust or forgive obligations, to create new ones, if appropriate, ones that may be more plausible, those things are critical in themselves as a precondition to restabilizing the economy and sort of getting ourselves back on track. That's it.
Amy?
Okay, thank you guys. Thank you both so much for that overview to break down the template. We have a question, and I think that this would really help just help give some context and put all of this into a real world scenario. So this person said they are an owner of a barber shop that's been closed since April, and they have not paid rent for April or May. Can they have a standstill agreement? Would that mean that they wouldn't be obligated to pay rent while in lockdown? How long could the agreement be good for?
Sure. So of course, we don't know the specifics of the circumstance, but to speak generally to a business that might be in such a posture, right? You certainly could pursue an agreement such as this. Now, this is, as the word agreement suggests, this is something that the counterparty, the landlord, would have to go along with. Parties would have to agree. Yeah, we don't like it. We're not happy, but you know, we are where we are. Who likes COVID? The best thing for us, we agree, is to everybody just time out for 30 days, 60 days, 90 days, whatever it is, right? And then would you ultimately be responsible? Well, this agreement, as you know, sort of off the shelf, doesn't anticipate changing people's relationships. So ultimately, presumably, funds that were due would fall due. That's something that would have to be addressed. This simply tries to stop the clock on either side, sort of, you know, taking a swing at the other or holding them to the letter of the contract, the underlying contract during these unusual times. Jonathan?
Yeah, no, I think that's right. And I think that small businesses of that sort, again, speaking generally, are really ideal candidates for this kind of agreement. As Norm suggested, because it's an agreement, both parties have to agree. But our hope is that because this is online, it's pretty accessible, even though it was written by lawyers. We think that we hope that it's a simple matter of, you know, one party saying to the other, listen, I know we haven't been paying rent, but we'd like to kind of clarify where things are. And so we'd like to, you know, agree for the next 2 months that this is what's going to happen. And part of what might happen is that interim payments of rent of some sort might be made, or a payment schedule to get, you know, current again will be part of the agreement, what have you. This is, we think, not possible if the parties are not talking to one another. Possible if the parties are simply litigating with one another. So although we obviously, you know, can't speak to any given situation, we think that those types of scenarios are good candidates for this kind of standstill agreement.
Yeah, definitely. And if I wonder, just practically speaking, if a good approach for a small business owner who's considering this, bringing this up to their landlord would be to maybe send the article. So it's saying, look, this is something that exists. This isn't me trying to do a trick. This is something that is fair given this time, and would just help lay out both of our expectations, both of the parties' expectations. So maybe that could be a good way to introduce it, just to not have it be something scary to the recipient. So I would think that.
I think that's a great idea. And, you know, one of the things we considered, of course, was that some landlords may be very angry. You know, you said you were going to pay, and if you don't pay me, I can't pay my mortgage. And, you know, people are legitimately feeling a lot of pain. But we're hopeful that, to continue the example that the questioner placed, you know, the barbershop, right? If the landlord decides he's going to get all, you know, litigious and lawyer up and try and take action against the barbershop, what's he going to do with the empty premises? You know, last time I looked, there weren't a lot of barbershops. I mean, look at me. There are not a lot of barbershops open in southeastern Pennsylvania right about now. So if people slow down and consider, we really are in this together, that may help them to sort of come out of their corners and be a little bit more cooperative and understanding, building for a future together.
I think that's a good point. And Jamie, it's funny that you suggest that. About a week and a half ago, I got my wife asked me if I would be willing to talk to one of her many cousins because some of his business partners were about to get into a fight with some of their funders. And my wife's cousin said, you know what, I don't think that's such a great idea, but I don't know what to say to them. I don't know how to talk them down off the ledge. I don't think now's the right time to fight. We might have to fight with the, you know, lender at some point, but now's not so great. I said, I've got something for you. And I sent him the link, and he sent it to his partners, and I think it helped cool them down. That won't cool them down forever. I mean, if things don't get better in the next couple of months, then they might have to have harder conversations. But I think that that's a great suggestion, Jamie, and I appreciate you're making it.
Yeah, and to just emphasize one of the things that you said, I do think that a payment agreement as part of this would be really helpful for landlords. So it's kind of like, okay, we're going to restructure, we're going to have it in writing, but you're going to get something. There'll be a little something. And it just shows a lot of good faith. So I think that's a good way to use this as well in terms of the lease agreement, to just have a little something, just to buy some good faith and make it a little more balanced.
And that's why we included that interim consideration provision. It's optional, but we couldn't agree more, Jamie. That's exactly right.
All right, so there is another question, but before people may have to head out because we're at the 1 hour mark. I just put in the survey, since we are funded by the Small Business Administration, and they help us provide these no-cost trainings. Please complete that survey for us. I'm also going to put that link that I mentioned, a resource page that we update every day that has webinar recordings and our upcoming webinars. I'm going to put that in the chat box as well. There we go. Okay, so please complete the survey, check out that resource page. Someone wanted to know if the PowerPoint itself would be available. I mean, I know the article has a lot of this information that we shared, but is it possible to share the PowerPoint with attendees?
Sure, yeah, I'll send you a PDF of the slides, and you're more than welcome to share them.
And then this may be slightly off topic, but we did have a question about lease terms that for a lease that would be executed now. So thinking about these provisions that you have, would you want to pull any of these out to apply to a new lease given the current climate?
So that's an interesting question. As I understand it, it's sort of I'd like to enter into a lease, but times are very uncertain. Do I want to build in any of the elements of the standstill agreement into my lease? My gut, and I used to be a real estate lawyer back when I had both thicker and darker hair, but my suspicion is that rare indeed will be the landlord who wants to deviate, is willing to deviate in any way from his form of lease. And I don't think that a landlord at the threshold of entering into a new lease is going to be terribly welcoming of the idea that, you know, we should plan for this pandemic thing because it is around. That said, I can fully understand why parties might find it advantageous to do that. It's kind of difficult to argue for the heart and soul of this standstill agreement as you're entering into a new agreement. Presumably, you've satisfied yourselves that you're both able to perform on an ongoing basis. Maybe you might take some inspiration from, item 5, the good faith negotiations and collaborations. You know, if folks were willing, they might sort of augment a standard lease with words to the effect that, hey, we're doing this at a crazy time, we're optimistic, we think it's going to work, but if, as a function of all the craziness in the world, it isn't, we agree we'll work together to try and make it better, and maybe even enter into a standstill agreement or what have you, if that helps us. Jonathan?
Yeah, I think that's right, and it's funny that the question came up because I've been thinking about a research project related to this little model, which would, sort of explore the idea that going forward, contracts could build in these kinds of timeout and sort of forgiveness or adjustment mechanisms from the outset. And Norm is certainly right. Lenders or landlords aren't going to want to agree to that necessarily unless they think they have good reason to do so. And of course, I think part of what we're learning today is that under certain conditions, they will have good reason to do so. And so I think it's certainly worth thinking about, building these kinds of escape, release valves into agreements. It might be difficult to get a landlord to agree to it, but it's certainly worth thinking about.
And Norman, I also think that maybe landlords are going to need to be more open because the sad reality is we are going to see vacancies. we are going to see a
Yeah.
scary amount of vacancies for brick and mortars that were housing small businesses, and a way to entice new businesses or bring businesses back might be some flexibility in the lease terms. I don't know.
No, I think you're really onto something there, Jamie, right? I mean, anyone who even casually follows what's going on in the retail and services sector these days knows that, you know, someone who actually wants to enter into a lease and open up a physical presence is rare indeed. And I suspect that landlords who sit down and think things through and respond rationally may find they have no choice but to listen to some things that in other times they would simply, you know, dismiss with the wave of a hand. Yeah.
Right. The creditworthy tenant, the creditworthy borrower has more market power today than they probably would in ordinary times.
Yeah, I think you can rent a small space at the mall for $1. You can rent the whole mall for $2. You know, I mean, there's some desperation, and that may inure to the bargaining power of the would-be tenant.
Yeah, so something to think about as small business owners, just being in a little bit more of a position of power, some small solace with everything that's happening right now.
Yeah, yeah.
So I think those are all the questions that came up. Yep, I believe so. Thanks again to everyone who joined us. I will send a follow-up email with the recording, the article that we discussed that includes the templates, and other just general information, as well as a link to the survey if you did not complete it yet. But thank you so much, Jonathan Norman. Thank you for just thinking about creating this document, and then of course being on webinars like ours today to explain it to small business owners who really need to hear about this resource. So thank you both a lot. We appreciate it.
We're happy for the
Thank
opportunity.
you for having us.
Okay, we're going to wrap up today. Thanks again. Be safe.
Be safe. Thanks.